Afternoon's topic is our inexorable laws. May I call Justice J Chandran, Naveen Singh, Sandhya Jain, Swati Goel Sharma, J Sai Deepak, and Nupur J Sharma. Swati Goel will chair this session instead of Mr. J Sai Deepak.
Hello, everyone. Am I audible? Welcome, everyone, to this session, our Inexorable Laws. It's one of the most important subjects right now. We hope to cover two important themes here. One would be on the role of judiciary under the Indian Constitution, basically judicial activism, and another will be on whether the Indian Constitution is at loggerheads with the Indic worldview. Before we start, I request the panelists to please limit your answers to 4-5 minutes because we will have 2 rounds of questions, and we will also like to take maximum questions from the audience. I'm sure you will have, this is a topic that you will be dying to ask questions on. May I please start with Justice Jayachandran? Sorry. Sir, do you think that the framers of the Constitution envisage for the judiciary the activist role that it is performing today?
Good afternoon, all of you. See, when the Constitution was made in 1949, of course, some of the provisions came earlier and some of them in 1950. I'm sure the makers of the Constitution, the members of the Constituent Assembly, could not have envisaged the present role of the judiciary. Of course, many of the laws were intact at that point of time. Some laws which were pre-constitutional in nature, some laws which had come after the Constitution. But then all of you know the Constitution is the mother of laws and the touchstone of all the other laws to check and see if it is valid, both in content and procedurally and substantively, whether those laws are just, fair and reasonable. Now, we have, some of you have read the Constituent Assembly debates. They are on about 5-6 volumes. Deep thoughts have gone into it. When the Constitution was made, many arguments going on. I mean, the chairman of the drafting committee, Dr. Ambedkar, was also against some of those provisions which were ultimately passed. He gave his own views. All the top people who had been elected to be in the Constituent Assembly, they had given their views. And when we see those debates, we can't find that, the role of the judiciary to be of this nature. It keeps changing. I'm sure as required by the society, as the, the needs change, I'm sure the Supreme Court or the higher courts have also been changing their views of interpreting the laws. Laws are statutory laws, basically, as interpreted by the courts of law. So therefore, I am initially of the opinion, unless somebody else finds otherwise, that the Constituent Assembly at the time, it took about nearly 3 years for the entire Constitution to be framed, from 1946 onwards. So yes, most of the provisions, or most of the powers, as we may call it, of the higher judiciary were contemplated by the Supreme Court. But now the Supreme Court has been changing its views, changing its colors, its dimensions, probably gone far beyond what was initially thought about, and sometimes far beyond what people expected to do. That is my initial reference.
Thank you, sir. In continuation of this, Sai, can I ask you, how does one reconcile judicial activism in a democracy? And also please speak on whether the collegium system is partly responsible for the judiciary being almost unaccountable.
So, if you look at the very nature of the judiciary, apart from the fact that it actually draws its validity or legitimacy from the Constitution, and since the Constitution is the will of the people, there is the indirect consent that you may have given to the setting up of this particular establishment or this institution, so to speak. But the fact remains that as far as the members of the judiciary are concerned, by and large, obviously they're not elected, and therefore for them to actually hope to speak on behalf of the people in some of these cases, in terms of recrafting what according to them constitutes public interest, is as good or as bad as somebody saying, I know what is good for you, as opposed to asking us what is it that we want and what we believe is good for us. Having said that, I do believe that judicial activism has acquired its negative and pejorative connotation today as a consequence of the lack of restraint observed by the judiciary. And it was perhaps a necessity at a time when you were faced with an inert, static, and a fairly corrupt system under largely what you know as the Nehruvian or Nehru-Gandhi dispensation. And at that point of time, perhaps the judiciary had to evolve a mechanism to address legitimate concerns, because the understanding in law is that wherever there is a right, a remedy is required for. It's called ubi juris ibi remedium, which means whenever there is a right that is established and there is an injury that is caused to that particular right, you have no other option but to devise a remedy. And if the remedy or the solution fails to come from the executive or the legislature, it falls upon at least the third arm of the state to provide some kind of a redressal mechanism, and that's how this was evolved. I think Justice Krishna and Justice Bhagavati can take large credit for converting letters and telegrams into public interest litigation. Now that's one. And the second part of your question is, collegium system largely represents perhaps the fount of lack of transparency, lack of accountability, and all in the name of protecting the independence of the judiciary. And the judgments that Indian Supreme Court typically falls back on for imposition of certain principles comes from both sides of the Atlantic, either the United Kingdom or the United States. And if you look at the appointments of judges in both these places, it's either by a Judicial Appointments Commission with a fair say of the executive, or a direct presidential appointee as far as the United States is concerned. So the assumption or the fear that is touted in India that the moment the executive or both houses of the parliament or both sides or both benches have some kind of a say in the appointment of judges translates to undermining the independence of the judiciary, shows that independence of the judiciary is effectively used to say that there cannot be anyone above us and there cannot be a watchman to watch the watchman. That, I think, is seriously problematic. And in a system of democracy which is largely subscribed to the Republican form of government, which is to say that we believe that the sovereign will of the people is the final word almost on everything, it is unfair to allow the unelected class to decide for people in the name of judicial activism and in the name of protecting rights and citing judicial independence. I think that is where the problem starts. Had they decided to stay within their Lakshman Rekha, perhaps these questions would not have arisen. But the moment you step out of the Lakshman Rekha, then naturally questions are bound to be asked.
Thanks, Sai. Ma'am, as a senior journalist who have been in the media for quite some time, could you please tell us, does the Contempt of Courts Act come in the way of the media scrutinizing the judiciary with the same vigor as it does with the other organs of the state?
Actually, the answer should be straightforward, because every action of the judiciary these days is so high profile that media comment is inevitable, and it follows, and it is plus and minus both. But the real issue here is not the contempt of court so much, which is of course being used also very harshly. Even senior lawyers are threatened in court that you stay within your limits. The issue is whether the judges should be having so much unilateral power, which is not based in the Constitution. It's not just the Constituent Assembly debates. We'll take the Constitution as a document passed in 1950, and a clear division of powers was given. Everywhere in the world, judges are appointed by the government of the day. In his case, he said even the president of the day, and everyone knows it. Now, coming to our appointed judges from 1950 onwards, they have been very independent-minded. When Justice V.R. Krishna Iyer, Justice Bhagavati, when they said that PIL will be the form of giving justice to the voiceless. That was regarded and welcomed as a judicial breakthrough because people who couldn't afford to come to the court could get a voice. Now the system has been perverted beyond belief. 1993, and I have to say this, otherwise it has no meaning, when Justice J.S. Verma came up with this idea of collegium, I condemned it then, and I have said it since, and Chief Election Commissioner S.Y. Qureshi was in a seminar with me. He didn't like it when the word I used, but I'll use it again. I called it a hijack of the Constitution, and that is what it is. It must be perceived as a hijack. Justice is smiling, but that is what it was because it has no basis in justice or in law. From there you get the problems. But let's go back. The emergency was seen as an assault on democracy. But in the emergency also you had judges who took a stand against it. Judges who could not be promoted because of it. Justice who was superseded because of certain views at that time. But they were all appointed by that same system. Nobody said then that we need a different system of appointing. And that is the crux of our problem. The appointment authority has to go back to the government of the day, even if it is Rahul Gandhi.
That's quite interesting, ma'am. One question, like another view from the media before I move on to Mr. Singh. Nupur, while interacting with people, what has been your experience when with respect to judicial activism? Whether the respect among people has increased of the judiciary or decreased? What do you say?
I think if I were to, this is being televised live, so if I were to use the words that we hear from average folk about the state of the judiciary today, then ma'am wouldn't have to answer the question about contempt because it would have, we would see it in action. So I would just like to say that before I was a part of this panel, Sai actually suggested that I should be a part of it and I should probably make some comments. And I told him that, what am I going to do between, lawyers and judges? My opinion would really hold no value. I'm not a lawyer. And perhaps that is the problem with our judiciary, that the people represented by the lawyers and the judgments that affect the people themselves who are affected the most are not really heard. From the people, there have been words which have been, the main sentiment, I think, today amongst the people is that the judiciary is skewed against the indigenous people of India, specifically the Hindu religion and the Hindu culture. The judgments are extremely high profile and perhaps they find roots and relevance in the constitution and the law, and I'm not equipped to answer. But the perception is such that the judiciary has taken it upon themselves to reform Hinduism. And the popular opinion is such that the justices and the judges and the courts need to decide whether they are the clergy and the representatives of a faith that needs reform, or they are interpreting the law. The faith that people had in the judiciary, when I grew up, fear was that we would do something, it was said that, you should stay away from lawyers, courts, and the police. And more than the police now, the fear is that you're going to land up in courts and going to be tied up for the rest of your life without a judgment. And God forbid you end up in front of the court as a Hindu and whose judgment is, whose case is dependent upon the interpretation of faith. Pardon me, I don't have a better word for it, but you're going to be screwed. There is going to be no judgment and there is going to be no conclusion. So the popular opinion amongst the people is that the faith in the judiciary has deteriorated, especially if you're a Hindu. They feel they are under siege by the judiciary. They feel they are under siege by judges who have taken it upon themselves to interpret their faith. They feel that the clergy has lost meaning, their priests have lost meaning, their faith has lost meaning, because the judges have taken on the mantle to tell Hindus how to pray, to tell Hindus what festivals they can or cannot celebrate, to tell Hindus when they can or cannot burst crackers, to tell Hindus how high the Dahi Handi pyramid can be, to tell Hindus how to live, and basically submit to minoritarianism, because their faith is always upheld by the judiciary. So at the risk of sounding, thank you, at the risk of sounding extremely rude and brazen, the judiciary has lost its value today, and it's seen in an adversarial role to the people, which is, I think, extremely dangerous.
It's actually quite sad to... What?
Now you know why I brought her on board.
Yes. No, it's actually quite sad to hear the reaction of the people they present to the media. And we'll talk about it a lot in the second session. A question to you, Mr. Singh. Do you think the judiciary has managed to inspire confidence in investors, Indian and foreign, that it is capable of deciding commercially important matters in a speedy and fair manner? It's a slight digression from, but yeah.
I'll take your mic. See this issue about ease of business and its interplay with the judiciary. It's a very important topic today, keeping in view the economic scenario of the country. But let's realize one thing, that I'm not a corporate lawyer. I don't practice on the commercial side also. I'm a writ lawyer. But let us realize one thing, that it is not the judiciary or the courts which are to blame in this aspect. You see, there's a labyrinth of laws created today, labyrinth of tribunals. We have commercial courts, and you have the appellate division in the commercial courts. You have the debt recovery tribunal and the debt recovery appellate tribunal, after which you go to the High Court and then to the Supreme Court. You have the NCLT, the National Company Law Tribunal, the NCLAT, the appellate tribunal for the National Company Tribunal. You have the IBC, the Insolvency Code now. There's so much of chaos. That in every transaction, on every issue, there are 2 or 3 tales of litigation going here and there. Something lands up in an appellate tribunal, the other thing lands up in the High Court, and ultimately they take these appeals to the Supreme Court, as if the Supreme Court is supposed to deal with these matters. I mean, we have reduced the Supreme Court to a regular court of appeal. So first, you cannot blame the judiciary for it. You cannot even blame the commercial entities for it. You need to sort out your laws. There has to be simplification of law. Now you have this GST appellate tribunal, which has been struck down by the Madras High Court, and rightly so. The laws need to be simplified. Perhaps we need only one judicial entity dealing with the commercial or the corporate aspects. A division bench of the High Court should look into the appeal/judicial review, and in points of law of general public importance, or if there is a conflict between 2 high courts, the matter should go to the Supreme Court. Otherwise, this chaos will continue. The ease of business will be a pipe dream. And again, I would reiterate that you cannot blame the judiciary for it. And even the systems of these tribunals and these appeals that we've provided, the presiding officer, the president of the National Company Law Tribunal, for example, is a retired Chief Justice of a High Court. And in the appellate tribunal, you have a Babu with 15 years of experience sitting there and overturning the judgment, sitting with a Supreme Court judge, technically overturning the judgments of a High Court judge, of a retired Chief Justice of a High Court. So these things need to be, these things need to be harmonized, simplified for the common person on the street, for commercial entities, for corporates, for everyone. There has to be a single system, and the Supreme Court need not be burdened with such matters. You have you have a court of first instance, or the tribunal of first instance, or a second appellate layer, and then the division bench of a High Court, and then the Supreme Court. So blaming the judiciary per se, and let me tell you why what Nupur was saying, I partly agree that the public does not feel very good about the judiciary, but there's a reason behind it. The reason behind it is that in a judicial process or in judicial functioning, there'll only be 50% satisfaction rate. Why? Because one party has to lose, the other party has to win. So 50% of people will always be dissatisfied with the judiciary. And the common refrain would be, oh, judge ne paise kha liye, ya dusra lawyer mil gaya. Judicial corruption is also exaggerated, I'm telling you. A process server taking money, or a reader of a lower court taking money to get your date is not judicial corruption. So judges cannot respond even the legal system, the lawyers cannot respond publicly like other entities can. The government has spokespersons, the army, the military has a spokesman, but judges cannot defend themselves. So let us also go a little easy on the system by trying to understand the intricacies, that it's not always that the judicial system has to take the blame rightly. Mrs. Jan was saying about contempt of court. Fine, everything is okay, but not everything should end up at the doors of the judges. And the executive, yes, the appointment system, the debate has been on since 1950, not just since 1993, the first judge's case, but since the inception of the Constitution, even in the Constituent Assembly debates. But there are always two sides to it. But let's also not forget that in India, the executive, the government is the biggest litigant. So you are asking the largest litigant to select the adjudicator. That may also not be the correct solution. So all of us have to think about the pros and cons, have to thrash it out. But I don't see a perfect answer coming out. But of course, the process must continue.
So I have a small comment, if you don't mind. With all due respect, when you said that the success rate is obviously, the satisfaction rate is 50%, my point was limited to issues of the faith. Now, for example, in Sabrimala, and obviously I'm assuming to...
the second part of the debate.
No, just one comment. I'm just assuming to make this comment in front of Sai and Sir because I shouldn't be. But the faith of the people, the devotees, was not against the ritual at all, if I'm correct. The litigants, the people who wanted the faith to be struck down, were not stakeholders in the ritual at all. So in this case, the satisfaction is going to be a negative 100% for the devotees because they are the only losing side.
See, I want to add, sir. I think you misunderstood a little when you said that that everything is blamed to judicial corruption. That is not the case, and 50% satisfaction or dissatisfaction is not the point. I want to make the point, 1993 onwards in particular, if not earlier, the NGOification or alignment of the Supreme Court and the high-profile judges with perception of leftist NGOs is very, very high. That alignment gives you the Sabrimala case. Today, the Tripura High Court has said animal sacrifices in Hindu temples of Tripura will not be allowed when it is an intrinsic part of ritual there. Then they'll do it in Assam and Kamakhya. And these are very important things. Now, can you imagine that Nirankari Hola Mohalla, if you say that the goat will not be sacrificed? Will the Sardars tolerate that? So, these are issues that are affecting the quality of judiciary. They take up cases suo motu, then they declaim as it is like fatwa-e-alamgir, it doesn't come across as a judgment. And these are the issues that people are going to take issue with. One day Supreme Court should not rule out the chances, and I say this with great reservations, but the chances of a physical reaction from the people should not be ruled out with the kind of provocation we have been getting on an almost daily basis.
That is not a... The matters of faith, etc., are going to be discussed in the second part, and I'm sure the judgment is also now again sub judice because they've had an open court hearing in the Sabrimala. So you should not be jumping to conclusions, neither should I be. And let's not divide the entire country into binaries of Hindu, Sardar and Musalman. It's very painful. It's very, very painful when you attach the judicial functioning of the nation or the common citizens. And the most dangerous thing that we are doing to this nation today is that the minority is feeling persecuted, the majority is feeling persecuted. I don't understand. I mean, where are we going? The minority is also saying that they interfere. The majority also says they interfere. Where are we heading? Everybody is feeling persecuted. All of us. No, forget the judges. What are we doing to us, to ourselves as a nation? We are just dividing ourselves.
Okay, a quick response from Mr.
Thank God I retired. The tirade that you started against the judiciary. See, it's not, I think we should look at it slightly from a different angle. It's not always that, you see a color there, that they're against the Hindus, or they're against Sikhs or Muslims. See, it all depends on what kind of case which comes. And what the, you see, probably when you say the leftist NGOs, probably they are the ones who are more active. They're going to the courts with more, options, more cases. Of course, in the second part of the discussion, we'll have something to do with the Sabarimala issue, which I'll also talk about. But the judiciary has said in clear terms, yes, we have a certain role to perform. We have overreached in certain cases. And we know intentionally we've overreached. Why? Because the legislature has failed, the executive has failed. Therefore, we had to step into their shoes. For example, the Visaka's case. MC Mehta. There are a number of cases where the executive did not perform. They did not do their duty. Therefore, we had to do it, giving directions to the investigators. In Visaka's case, they lay down all the guidelines of harassment in workplaces. For example, child laws. Many states had not enacted child laws. So the judiciary had to say you have to enact laws relating to children. There are a number of issues which come up not only on the judicial side, also on the opinion which the Supreme Court can give. The other thing is, yes, of course, sometimes you have the decisions going against popular opinion. Suppose they said, don't use crackers during Diwali. They say use green crackers. We don't know what that means now, probably which causes less pollution. And when they say use, for the buses in Delhi, you'll have to, use the CNG. Or don't burn stubs in the wheat fields in Haryana and Punjab. So, the number of things which probably the government of the day should do, they don't do. So, therefore, the courts are asked to decide on such issues, which normally they are not expected to do. In fact, I used to say when cases come before me regarding the river sand being excavated and taken away, then I used to tell it's your duty. The government, it is your duty primarily to see to it that river sand is not misused. And maybe in future we'll find a small bottle somewhere in a museum saying this is sand. I mean that is what you have to do. You failed to do, and all these matters come before the court, and the perception probably rises from there that the courts are interfering with a whole lot of things which normally they are not expected to do. And also to remind you that there is an article in the Constitution, which is Article 142, that the court can pass any order to do complete justice, much beyond what the petitioners ask for in their prayer. So, see, the lawyers are there on both sides to argue, bring it to the knowledge of the court as to what are the facts, the law applicable, and therefore, a particular kind of a decision is taken. And if it is a lower court which takes a decision, then there are appeals to go to the higher courts. This perception, which you would call it as a popular perception, that the courts are against a particular religious group may not be true or may not be correct, in my view.
I have a response to that, but I'll answer
just
it in
two
the
quick
course of the second
responses
round.
from Mr. Singh and Mr. Sai, then we move on to faith. So,
A very short thing I would say about judicial activism. What happens is that when the executive fails to perform a very basic duty, anything, even the smallest of things, and a member of the citizenry, a member of the civil society, he or she goes to a court under the High Court under 226 or to the Supreme Court under 32, saying that we've been writing to them, we've been requesting them, and this is not being done. It may be a very small little issue. The courts cannot just fold their hands and say, oh, okay, sorry, can't do anything, judicial activism. So if there is a fundamental right being infringed and a citizen goes to a high court or to the Supreme Court, I'm against citizens going to the Supreme Court directly unless there's a multiple dimensional thing affecting all states. But if a person goes to the High Court, for example, saying that this is something wrong which is happening, I've been writing, no response, my fundamental rights are affected, you can't expect the courts to close their eyes. Sorry, that would be against the constitution. They have to open their eyes and do something about it.
Please keep it brief, sir.
Yeah. So just 2 points. One, I don't think it helps to divide the let's say the society on the basis of religion when it comes to secular matters. But when it comes to issues of faith, you're naturally bound to look at it from a religious lens. You will look at an issue relating to, let's say, an SGPC as a Sikh. You will look at an issue with respect to Sabarimala as a Hindu, or even a non-Hindu who believes in Ayyappa, or you look at, let's say, the issue of triple talaq necessarily as a Muslim. That does not amount to dividing the community or the society on the basis of religion. That is to accept that there are religions and that there is a separate, let's say, there are separate belief systems. So that's one. Second is, and as someone who has heard a lot of comments from people after the Sabarimala verdict, and these may or may not reflect my views, and that is a necessary caveat which has to be underscored, is they say, so you guys don't spare any issue from being branded as a Brahminical or as a manifestation of Brahminical patriarchy the moment you hear issues of, let's say, untouchability or whatnot, and you necessarily trace it to some scripture of Hinduism. And when 1, 2, 3, 4, 5, 6, 7 judgments keep coming one after the other with respect to Hindu practices, you stop us from drawing our own conclusions with respect to what must be the intention. So don't you think it actually is hypocrisy that sometimes you necessarily fit certain instances within your basket and say that this is casteism, this necessarily has to be traced to Hinduism. But when the judiciary does it, you're saying that observe a bit of nuance. And because it has to be on a case-to-case basis, and that one summer or one swallow doesn't make a summer. This is not one swallow. These are 10 different swallows, and therefore necessarily this has to be treated as summer. If you have 10 different judgments, and you don't expect the common person to go through a 1500-page judgment, which are almost like novels sometimes, or 200 to 2000 pages, 7 chapters, each one writing a book of about 250 pages. So when that happens, and that too in language for which I think you need not the 20th century's version of the Oxford Dictionary, the Merriam-Webster's Dictionary, you need perhaps the 18th century's dictionary. Okay? So when you start doing that, people ask themselves, you using this kind of a language in a commercial matter where there is a degree of sophistication between the parties is a different issue. But when you're dealing with issues of faith, which necessarily have an implication on the common person, shouldn't it be, or is it wrong on the part of the public to expect simplicity, lucidity, fairness, and a fair level of understanding that perhaps some of these practices are beyond the scope of adjudication by a secular court because you're not trained in that particular area of practice, as simple as that. If you take the particular position, you can't blame the people for asking themselves this question, is the dice loaded against me as far as some of my issues are concerned the moment I approach this forum? And that is a legitimate aspiration. And I don't think any organ of the state in a democracy can hope to be immune from that kind of an aspiration or expectation. You are necessarily answerable. In fact, while we say that the judiciary does not have a spokesperson of its own, you're speaking through your judgments on a daily basis. That is a fact. And you don't have a spokesperson because you've decided to be an institution which is immune from scrutiny. So you can't say, oh, I don't have a spokesperson and therefore it is unfair to actually put all of this blame at my doors. When the fact is, you're saying that I must be treated not at par with the rest of the institutions under this particular constitution because I am different. I have a special status, almost like a 370. Therefore, the rules of scrutiny that apply to the other two institutions do not apply to me. The moment you say that, then naturally people are bound to find other ways of giving vent to their frustration, exasperation, and anger.
Okay. So we'll be talking about religion and judgments like Sabarimala and the Handi in this session. But I would like to first start with Mr. Singh. Sir, given the backlog of cases in the Indian courts, do you believe Indian courts should be so liberal in entertaining PILs on religion, related to religion?
I'll talk of PILs in general, not just religion. And as far as religion is concerned, it's not just Hindu practices. You know, there are judgments against the SGPC in 6, triple talaq, Shah Bano's case. There are multiple things. Just naturally, since the percentage of Hindus is more in India, naturally, numerically, those judgments can be more. But it's, yeah, I mean, religious practices have been under the lens, not practices per se, religious issues, I would say, have been under the lens of the judiciary and not just restricted to one religion. On PILs, absolutely, I agree that the scope of PILs has to be reduced. It should not be publicity interest litigation. We've had live instances wherein, opposing business entities have been trying to use the tool of PIL through NGOs or through other people to stall something or to create an impediment in a business entity's enterprise, then you find people who are yet to file a PIL and the entire PIL is reported 10 days prior to filing of the case, and there's a huge hullabaloo and a huge debate which starts even before the court hearings, the court starts hearing the case. Yes, I totally agree that the scope of PILs has to be restricted. Having said that, genuine issues or issues which do affect a citizen, do affect his or her fundamental rights or the society at large, they cannot be, we cannot keep them away from courts. Has to be a greater scrutiny, and again I would say that the high courts should be the preferred courts for relief in this, not the Supreme Court. The Supreme Court should not be burdened. Today we find that the majesty of the high courts is going down because high courts are just being used by litigants as a stepping stone to go to the Supreme Court, which is absolutely not correct. The High Court and the Supreme Court, they are the highest constitutional courts under a federal system. The High Court has equal powers, even wider powers than the Supreme Court. 2 to 6 is like 2 plus 2 is equal to 6. So the majesty has to be retained. Practically speaking, the High Court has to be the highest court for a common citizen unless there's a point of law of general public importance or there's a water dispute or dispute between states, etc., or a very large constitutional question which may affect the society at large. And for that, perhaps we need to increase the intra-court appeal jurisdiction, not just in the letter patents area, but under the LPA area, but maybe in the future we may have to do that. Direct appeals from tribunals to the Supreme Court have to be totally stalled. It is absolutely against any democracy, against L. Chandrakumar's judgment, against Madras Bar Association. We are making a mockery of the Supreme Court. The highest court of the land is hearing, for example, appeals of 500 rupees from the Armed Forces Tribunal, whether pension should be 500 rupees or 600 rupees a month. It is totally making a mockery of the system. The High Court has to be the highest court of the land. There is no 2 to 7 over the high courts, as you know, small little interference. There's an interim order and person runs to the Supreme Court and takes an order, interim order against a high court decision, high court order. So all these things have to be kept in mind. PIL has to come down, restricted, but also other litigation. The Supreme Court has to be left only for constitutional questions and issues involving general points of general public importance and where there is conflict between different high courts.
Sure, thank you. Sir, a direct question. Is the Indian Constitution is fundamentally at loggerheads with the Indic worldview?
I think if we say yes, we'll be doing great injustice to those great legal minds who framed the Constitution. But of late, as of course some of you had alleged, see, there are issues which the Supreme Court has taken up, maybe on compulsion. See, if you take the case to the Supreme Court most often, it can't say, I can't decide the issue. It has to decide one way or the other. Of course, sometimes PILs, go before the Supreme Court and they dismiss it and with heavy costs because if it is frivolous. But most of the PILs, especially by NGOs and other people, have some substance, to be dealt with. So the Supreme Court spends time and energy in trying to find an answer to it. Of course, with special reference to probably Sabarimala issue, in fact, I've been quite involved in those debates. See, what had happened is in Sabarimala issue, as I saw it, Article 14 and of course 25, all read together, they said it should be open to everyone to worship, including women of a certain age. Now, the question was as to whether such deep faiths of religion can be interfered with such cold law. What we call the law is pretty cold. I mean, it doesn't see as to what kind of faith they have, what sentiments are involved. It just applies the law directly. And of course, a review is pending. That way, it may be sub judice. But what most people, as I saw, felt was that the judiciary should not have interfered with that kind of a deep faith which people have. For example, there is in Kandy, you must have read that there is a Buddhist temple where Buddha's tooth is supposed to be kept. And there is a huge crowd going and worshipping that in that temple. Now, can the court, any court for that matter, say you do a DNA test and see whether it is Buddha's tooth or not? It's faith. I mean, like that, you have Hazrat Bal mosque in Kashmir, where Prophet Muhammad's hair is supposed to be kept in a casket. And at one point of time, it was lost. We don't know how it got lost, but then a whole lot of people, the police, paramilitary, and a whole lot of people were put, asked to search for it, and then somehow they got some hair and kept it there in that mosque. And and now, of course, everybody is satisfied that this must be Muhammad's hair. Now, can we say, okay, do some test and find out whether... See, these are deep faiths of religion. It doesn't matter which religion it is. It may be Hindu religion, Muslim, or some other religion. So, if there is some deep faith which they are following, which is not harmful. Sati, for example, was harmful. I mean, the wife jumping into the funeral pyre and killing herself when the husband dies. Or child marriage for that matter. But if something is not hurting anybody mentally or physically, if any particular religion or a section of the society has deep faith and they are following it, why not let it be? That is my question, left open to be decided by Supreme Court.
I'm sure you would have a lot to say on this. Also, as somebody who has handled INDIC cases, what do you think is the legal resource the best way to secure the INDIC interests?
Yes and no. It's a lawyer's answer, I'm sorry. But the one thing I've realized is the amount of ingestion that we have done of the white man's reading of our history, right from the exaggeration with respect to practices like sati, particularly when trained historians have established that this was not as prevalent as they made it out to be, that the circumstances were different, and that the white man came along with someone who had another book in his hand, a holy book in his hand, and one served the purpose of the other, and both of them were hand in glove, as thick as thieves, and both of them were furthering each other's agenda, and therefore it certainly helped to paint some of our practices. So for instance, the Devdasi practice has been so distorted, contorted, and taken out of context, and it has been reduced to what they call as temple prostitution. They don't understand the philosophy, they don't understand what it has engendered, they don't understand the kind of people that they've produced. How many people know that M.S. Subbulakshmi comes from the Devdasi tradition? She's not a Brahmin, but ultimately she's been celebrated across the world. And frankly speaking, they have not understood these practices at all. So therefore now you see how education has effectively fueled certain thought processes and certain worldviews, and that ultimately reflects in the judgment that comes out with respect to what they think is how India was and is, and now therefore there's a perpetual state of reform, that this is a never-ending process. So one thing is, whether you succeed or not in a particular litigation, just as sir pointed out, NGOs keep filing cases, you should go as well. That is precisely why you should go, because there should not be an unrepresented voice or view in the court, so that the court knows what exactly is the point of view, that there is an alternative point of view. Otherwise, if there is only one voice and only one thought process that is being represented in court, then they will establish that there is no counterpoint at all, and therefore this is a truism. Therefore, regardless of the outcome, regardless of the success rate, you have no other option but to stand there and represent, because whether you succeed in a court of law or not, you will at least manage to get the word out in the court of public opinion. And to a significant extent, there will be a tidal change. So let's put it this way. 2009, the Delhi High Court of Justice A.P. Shah and Justice Muralidhar came out with the position that Section 377 deserves to be struck down. Okay? Then the Supreme Court takes a different position. Then in review, it has taken a different position, which is now a longer judgment endorsing a crisper, better written judgment of the Delhi High Court. According to me, it's a better written judgment. I'm entitled to that view as a lawyer. So it's not a contempt of court at all. So according to me, this was a better written judgment. Now, if that is the case, what happened between the judgment of the Delhi High Court and the final judgment of the Supreme Court in 2018 is public opinion and a fair amount of advocacy, legitimate advocacy to ensure that science is brought on record and what not is brought on record. So to not have your position represented in a court of law is not an option, it is necessary. However, whether it will yield to the expected results or favorable results is always a coin toss in the air. And inevitably, you know what the outcome could be. But nevertheless, you must at least lay the grounds, lay the foundation for your positions. That is my opinion.
Okay. I'm sure Ms.
I
Jain.
want to make very crisp few points. One, as you know, my name is Sandhya Jain and I'm a Jain. Not a very adherent kind, but still culturally a Jain. And our community has been under attack by these leftist NGOs for a very long time. Recently, our most famous Muni, Vidyanandji Maharaj, he announced Salekhna, the Jain practice of refraining from food and water because he perceives that his end is near. And he took Salekhna, and within 24 or 28 hours, he passed away very peacefully. Because there was no hula bulla this time, the event was not even reported. This is shameful. He was such a great person. But before that, some years ago, some NGO went, and these leftists are always creating problems for us when some Muni or someone is taking Salekhna or some individual is taking. My uncle has taken it, so we know what it is. And they are always pestering us. Some years ago, they went to the Supreme Court and they said, these NGOs with nothing to do and they are well funded. This is the point I'm making about NGOs. They are funded when they go for PILs in the Supreme Court. And luckily for us, we as Jain community had a lawyer of the level of Abhishek Manu Singhvi. He represented us. Then a supreme leftist intellectual like Bhanu Pratap Mehta, Professor Mehta, former VC Ashok University. He's also a Jain. So he was also on board on this because they are both believers. And this thing was scuttled at that time. But this was when Sabrimala came. This is soon after your Sabrimala judgment. When the Sabrimala judgment came, I started crying. My son said, what happened? I said, now we are the next target. And within weeks, the thing came in the Supreme Court that this Jain practice has to be struck down as unconstitutional. But because of the level of our advocacy and the lawyers we had, we won that case. Now, if Supreme Court is going to get into this thing according to who the lawyer is who's bringing it, mostly it is this gentleman, Prashant Bhushan. And all these peculiar PILs come through him. Sometimes you'll be shocked, and I'm just to my last point, my two small points. What Mr. Singh said is totally wrong. The Supreme Court has very much spokespersons, and any major newspaper like Hindustan Times or Times of India, you can pick up Indian Express. You will find Sri Kapil Sibal there giving the Supreme Court version. Mr. Dushyant Dave will be there giving the Supreme Court version. These people will be on TV telling the Supreme Court judges what they are to think of something, what they may like to think on an issue. And the whole, it's a vicious circle. Final point, and if you don't believe me, in London recently, an 11-judge bench of their highest court said that the prorogation of the Parliament by Boris Johnson and the Queen was illegal, and they struck it down. And this is so wrong legally because they have absolutely zero jurisdiction, but this is the kind of peculiar activism which is taking place. After that, one very prominent Twitterati said, now that the London judiciary has done this, are we going to draw the right conclusions? In the form of the right conclusion, the Supreme Court today has said, we are going to take up the legality of Article 370 and Article 35A. So I rest my case. We are having something very wrong in the Supreme Court, and we really need to look at it closely. Thank you.
So I think you'd like to respond to it.
See, last year in the Pondi Lit Fest, we were talking about LGBT and 377 and also triple talaq. I think our predictions came right. But you will very soon expect the Uniform Civil Code issue coming up. I'm sure the government, after this 370 and 35A abrogation, it's going to push for the bringing in of a Uniform Civil Code, which is there in Article 44 of the Constitution, of course, part of the directive principles. Now, one other thing which a friend pointed out, is the judiciary overburdened? Now, if so many cases come up, in fact, the Federal Supreme Court of the United States of America probably decides in a whole year, probably much less than what the Indian Supreme Court decides in one day. And they have the top Ivy League researchers to do the research for the judges. All 9 judges sit together to write judgment. Here we don't have that kind of course, some of the judges have their own researchers, students who help the judges do it. But in fact, if somebody walks up to me and says, sir, you have written a very good judgment, I say it's because of you. The lawyers, as you rightly said, see, this is part of the system. You get some of the best lawyers, and of course it's very expensive. So what about a poor man who doesn't have access to these very expensive lawyers? Of course, every senior lawyer in the Supreme Court is supposed to take up one pro bono case a month. But that is not sufficient. So this problem is also there, whether the defense, if somebody raises an issue, if the defense is not sufficient, maybe the court will be inclined to decide one way or the other, of course on merits, but they can't keep doing research in every case which comes before it. So the lawyers are also equally important in the entire system to decide a case better, in a better manner, more on merits. That's what I feel.
I'll just make one point and leave it at just one final
We are
point.
actually really running out of
I'm
time.
done.
I just wanted to ask Nupur a question, please.
No, so the thing is this, just to give credit to people who actually worked on the Sabarimala case, and this is not about me, we were represented by, I think, the finest brain alive on constitutional law, Mr. K. Parasaran. I think there was no stone left unturned in giving this cause the best of representation in both the rounds. And the second round, in fact, a lot of other luminaries, they got on board. So I think it's important to realize that some of these outcomes don't reflect the quality of advocacy, but perhaps the approach to some of these issues. This is not to take away from anybody's efforts at all. I did whatever I could, that's a different issue. However, with someone like Mr. Parasaran having led the way as Bhishma Pitama, I think it's very, very important to give him credit on a public platform that we were represented by a 92-year-old constitutional expert who has come out of retirement for Sabarimala and Ram Janmabhoomi, and whose son gave up his position when the government decided to take a position against Ram Setu, saying that this is part of my faith. Sri Mohan Parasaran quit his job as the ASG of the country. So I think this family's legacy has been to defend Dharma all along. I've worked with them, I know how they operate. It's fantastic. So I will never say that the outcome is a reflection of the quality of advocacy. I think the job was done.
Truly. We have just 5 minutes. I'll quickly ask Nupur, and then I think we'll have time for 1 or maximum 2 questions. So just 1 second. Nupur, again, do you think Hindus, Indic people get a raw deal from the Indian courts?
With all due respect, sir, you mentioned the triple talaq case, and you also said that the law is cold-hearted and it doesn't really pay attention to faith. But if you recall, in the triple talaq case, the judges actually went and found where they were trying to find whether the practice finds sanction in the Quran or not. While they were doing that, the Sabarimala case has been pending for 7 months. Now, my question, of course you don't have to answer this, but my rhetorical question is that what if someday some person from the minority community goes up to the court and says that killing idol worshippers is my religious right? Is the court going to go and consult the holy book and pass a judgment saying, judging whether killing of idol worshippers finds sanction in a religious text or not? The point is that the minority community's faith has found far more respect in the judiciary than the majority faith. We saw the people of the country come out on the streets and defy the Supreme Court in the Dahi Handi case. We saw the same in Jallikattu, and we saw the same in Sabarimala, where, of course, they were not defying anything, but there were widespread protests and people were up in arms against the Supreme Court. Right now, she mentioned like Tripura, the animal sacrifice for the Hindu festival has been banned. But when it came to Eid, the court said that you can sacrifice the animals on the terrace of your house, but please don't do it on the roads. Sorry?
Two different high courts.
No, that's fine. I am not an officer of the court, sir. So for me, whether it's a Supreme Court, High Court, Sessions Court, local court, it's the judiciary. And I would feel that the judiciary is up in arms against my faith, whether it's a Sessions Court or the Supreme Court. Because one after the other, there are practices of the Hindu faith which are under siege. Whether it's Dahi Handi, whether it's Nag Panchami, whether it's Sabrimala, which is one temple, one ritual, not something which finds sanction across the religion. The problem also is that the court is referring to the Quran, but we are not a monotheistic faith. We don't have a codified book. So all our traditions and practices, which are going on for centuries and centuries together, oral traditions, is the court going to strike it down because it finds no sanction in no book? Because we are not monotheists. We don't have a Quran. We don't have a Bible. So where are Hindus supposed to go if the Supreme Court is referring to the Quran and striking down our oral traditions and is up in arms against our faith?
Thanks for that question on idol worshippers. I think was very interesting.
Just to add one couple of sentences on what Mr. Sai said. See, when I'm one of the vice presidents of this All India Council on Save Sabrimala. We've been working on it. In fact, I had a deep discussion with Senior Parasaran, Mr. Parasaran. He also felt, this is inside information, that the government can bring a law, not only for Hindus, for all the other religions as well. If there is a deep faith, being followed, it's a particular practice being followed by a particular religion based on mere faith, which is harmless to people, then there should be a law to protect it. In fact, when they first came to me, I said, you have let the tiger escape from the cage. You are just holding the tip of the tail and trying to pull it back. Because this is now in a review situation. You know how difficult to get a review in and then get a decision in your favor. And what happened, I'm not sure who are the lawyers who had appeared at the initial stage. It's been pending for many years. And I'm not sure whether you were there from the beginning. But at this stage, of course, a lot of people have come in, and then they are giving in their inputs. But whether what was done earlier at the beginning was good enough to tell, at least request this, the Supreme Court, look, form a committee and let the committee of experts go into it and give the input to the court. What I was trying to say was the court doesn't have that kind of resource to study in depth Quran, study all the scriptures, and then give a fair judgment. This is what we meant.
Made by both Dr. Singhvi as well as Mr. Parasaran, representing the Devaswam Board and the NSS, both in 2016 as well as in the hearings in 2018.
Sure.
That was done.
Thanks. I think we'll have the time at least to take one question. Yes, sir. And please specify who do you want to answer.
I think the point was made that the court is not really anti-Hindu, and to the point of Sabrimala perhaps represents the final coffin of Article 26 not being applied for any Hindu, starting from 1954 Shirur, Nallur Marthandam, SP Mittal. Every case, the Supreme Court has decided to refer to Webster and Oxford for faith organization name as the benchmark to decide whether it is denomination or not. And not even once in those 10 judgments, SP Mittal, of course, all of you are aware, is Auroville. And Ramakrishna Mission, every judgment on Article 26 has referred to Webster, Oxford. Why is it the judges have felt it beneath the dignity to refer to the Hindi version that says it is Sampradaya, and denomination, as all of us know, is a Christian concept.
Sure. Thanks, sir. Do you want, who do you want? Is it directed at Justice? Yes, sir.
Why the judges have chosen Oxford and Webster and not the Hindi version of the Constitution, which was ratified when, Chai?
I'm not sure. We'll have to ask the...
Will anybody... Yeah.
No, if they have referred... See, that's why I was saying, what happens is, if you see in the court, the lawyers who present the case, See, of course, every case has to be decided on its own merits and based on the law. And the lawyers who represent the cases also matter. It's not that none of the lawyers here can say it doesn't matter. It does matter. So if the lawyers present to the court these materials, and the courts will decide the cases on those materials available. They're not going to go search around all the libraries, get information from various quarters to decide a case which is before them. We are not sure. We should ask those judges as to why they did that.
Excuse me, sir.
Any
I
other
would like to
question?
make one small point. In Sabrimala, since you talked about that, Sabrimala had a perfect judgment of the Supreme Court in 1952. And that judgment has been overturned this time in 2016. And it has been overturned on the basis which Justice Indu Malhotra pointed out, that the petitioners who have come before us have no locus standi. They are not even from Kerala. Why are we entertaining it?
Just a correction.
That is
Ma'am is
something
referring
to
to-
go home with.
We have actually
Ma'am is just
completely run
referring
out
to a
of
judgment
time.
of the High Court, of the Kerala High Court, and therefore she has said that they have approached the Supreme Court 11 years after the passing of the Kerala High Court judgment, and therefore the matter has attained finality. And if the very same issue has been dealt with, and you have not appealed against the judgment of the Kerala High Court, what sense does it make for you to approach the Supreme Court in a fresh petition under Article 32? That was her point.
I wish we
Sorry?
could continue, but we really can't. We are
So,
completely run out
it was
of time
repre-
here. So,
I'll answer this.
yeah, we'll end the session here, and we hope this, this anti-Hindu so-called, or being one anti-religion sentiment is also goes down and is fixed, and the people are hearing. Thank you very much.